Thank you very much for coming in. My name is Kleanthous. I'm a solicitor. I work with a firm called Gannon's. We are in Holborn. We specialise in advice to SMEs, directors, doing commercial, corporate and employment type law. My own specialty is dispute resolution, litigation, and one of the issues I find often is that in the course of your business, you, like me, and here's something we have in common, resolve disputes. You have problems coming up all the time with customers, with suppliers, with other businesses, and one thing you do is you settle them, you resolve them. You may not think of it as doing that, but that's what you're actually doing. And there are a number of pitfalls involved in that I want to highlight this afternoon in order to give you a toolkit to be able to solve the disputes yourselves, get it right, avoid problems that come after that, and also know when some red flags arise, when something's actually a bit more complicated than it looks, and you might want to speak to somebody to get some advice on it. I'm going to talk about a few things, and I'm not going to apologise. There's a bit of law involved in this, because I'm afraid that's the way it works when you're settling disputes. I'm going to talk about concurrent liability, what happens when there's more than one person involved. Sometimes the dispute is A against B, one person against one, but quite often there are a couple of parties involved. For example, you had some work done on your offices and there was the architect and the builder. And if you do a deal with one of them, what about the other? And I'm sure you can think, I see a few nods. You know, sometimes, is it them? You want to do a deal with one, not the other, or with both. So I'm going to talk about that. I'm going to talk about the check in full and final settlement. How often have you had here's a check in full and final settlement, and it's not enough, and you don't want it. Can you cash it? I'll tell you the answer to that. Mistake and misrepresentation issues that come up whenever you're dealing with contracts. Enforcement, crucially. You may do a deal, but how are you actually going to enforce it? And then third-party rights that can be involved as well. The first and most crucial point that I want to get across, though, and if you take nothing else, take this. A settlement is a contract. A settlement of a dispute is a contract between you and the other person. Now, if I say to you, are you used to negotiating a contract? You're going to say yes. You're used to doing that. You do it all the time. And there are a lot of things that will come to your mind and things you need to know, you need to watch out for when you're doing a contract. A settlement is the same. Everything you know about negotiating a contract, you need to think about when negotiating a settlement. You need to think about offer and acceptance. How are we actually going to get a deal? What is the deal? Is there consideration for it? Again, as you probably know, a deal is only an enforceable deal if somebody's giving something to the other party. And that could just be agreeing not to sue them. But you've got to have offer and acceptance, consideration, certainty, and an intention to create legal relations. If you don't have those 5 things, you don't have a contract. Not just with settlements, but ever. There has to be an offer and an acceptance of that offer. It's no good if one person says one thing, one person says another, you never actually met in the middle. There has to be some consideration. It has to be sure what it is. So, for example, if I agree to sell you something but we don't agree a price, there probably isn't a contract because we haven't got enough detail in there. So, concurrent liability. You've got a situation, I'm simplifying a bit, X and Y are both liable to A. A has a claim, but against X and Y. It could be a contract, it could be for something like negligence. This is a hellish complicated area. I'm not going to try and teach you the law of concurrent liability because, well, I have to go and learn it all myself first. The House of Lords, the Supreme Court has cases on this. It is very, very complicated, and I'm not going to try and, I'm going to give you a little bit of detail, but I'm not going to try and teach you the whole thing. I'm going to try and tell you what to watch out for. Typically, then, the problem is going to be, and don't worry about the detail here because I'm going to give you the simple answer at the end of it. You are A. You have got a claim against X and Y, possibly both. Or somebody might be making a claim against you and there's somebody else on the hook with you. The person with the claim may well want to settle with one party and still go against the other party. Very typically, one of them's willing to do a deal and you're happy to settle with them, but you're not letting the other guy off the hook. You're owed £1,000 by both of them. You'll take a couple of hundred from him, but you still want to go after him for some more. Also, you want to be sure you're out of it. And that's why I think I've got my A's and X's confused there. X wants to be sure he's out of it. If you're the one who's paying, you want to be sure that is an end of it. You do a deal with the guy who's claiming from you. What you don't want is another claim coming round the corner from the other person, from the person who's also liable to you, which could be in several ways. There could be a contractual indemnity. There might be an agreement between you. There's an act called the Civil Liability Contribution Act, which says that when two people are liable, if one person pays, he can actually get a contribution from the other one as a separate right. So if you're the one who's paying, you want to know that that's an end of it. If you're the one who's getting it, you might well want to stop that happening. So there are any number of different ways the money can go round. What you can't do, and this is the important bit here, is that two people can't stop a third person suing. So A and X between them, two people can't agree that a third person can't sue them. That's not open to them. So the problem is, you're going to do a deal, there's more than one party involved possibly. You want to make sure that if you're the party getting the money, you're getting everything, or you know whether you're going to be able to sue anybody. If you're paying, you want to know that's going to be an end of it. How do you do that? It's complicated. The key point here, and I'm not going to go through all of it, clear language between two parties isn't enough. You need to make it very clear as between three. If you want these notes after, by the way, I'll be very happy if you send me an email, my details at the end, be very happy to email them to you, so don't worry about taking notes. The point here is that the deal between two doesn't affect a third, and that's what you need to watch for. Therefore, and this is the key point, be clear and be specific. The simplest answer to how do I make sure that I get the deal I want is you write down what you mean. You are going to pay me £200, and in return, I'm not going to sue you for anything. But I'm still able to sue him, and therefore, if he comes after you, that's your business. That makes it clear. Or, you're going to pay me £500, I've got a claim against you two, you're going to pay me £500, and in return, I promise I'm not going to sue him as well. And that way, this person knows that there isn't going to be another claim coming at them. There are any number of ways, and what I can't tell you is what deal you want to do. That's going to be up to you. You're doing the business. What I can tell you is, make sure that it's clear, make sure that it's written down. And you can do it in a number of ways. You can have what's called a reservation of rights. I settle with you, but I'm still able to sue him. If that's what you want to do, write it down, make it clear. I'm settling with you, but I promise I'm not going to sue that other person. Therefore, you can't get another claim, a covenant not to sue. That's perfectly valid. The language is technical, reservation of rights, covenants not to sue. The idea is simple and straightforward. You say what you mean. You can undertake not to sue. There can be an indemnity. I'm going to sue, I'm going to claim, you pay me fine. I might sue him, but if he tries suing you, I'll take care and pay you the money back. That might be a deal that's being done. It is a complex area, and I'm whizzing through it a bit because our time is fairly limited. The questions to ask yourself are, and again, this is the key practical point. If you're paying, if you're the person who's paying on the deal, is there anyone else who might claim against me? Is this going to be an end of it for me, or is somebody else going to pop up? If there is somebody else who might pop up and claim against me, what's going to stop them? How am I going to deal with that? Or is that just a risk I'm going to take? It's fine just to take that risk, so long as you know you're taking it. What you don't want to do is shell out a load of money to him and then find her coming at you unexpectedly. If you're the receiving party, if you're getting paid, is there anybody else I might want to claim against? I'm getting paid by that person. Is that an end? Am I happy to leave it at that? Or am I going after somebody else for some more money? Is there anything in this settlement that might stop me doing what I want? Those are the questions that you need to ask yourself. I'll move on now to the next topic, the check in full and final settlement, because this is one people are always interested in. can I send somebody a cheque in full and final settlement, and if they cash it, is that an end of it? Or somebody has sent me a cheque, they've said, here's a cheque in full and final settlement. You say we owe you £1,000, here's our cheque for 600 in full and final settlement. Can you cash it? The answer probably is yes. Most people think you can't. Surprisingly, the answer is probably you can. And it's a fairly complicated contract point. I'll try to simplify you. If there isn't a dispute, if it's clear that £1,000 is due, then there isn't going to be any consideration for the settlement. You remember earlier I said in order for there to be a contract, there has to be consideration. You have to be giving something up. If you owe me £1,000 and we both agree, and you agree, you owe me £1,000, no questions, you don't argue. Don't worry, you don't. But just let's pretend. And you come and say to me, "Here's £600. Will you take it?" And I take it. I can still come after you for the other 400 because you haven't done anything more than pay me what I'm already due. There's no consideration for it. You already owe me £1,000, so why is paying 600 get you off the rest of it? It doesn't. So if there's an open admission, an admission you can use in court, if something's on the record, that amount is due, simply paying less isn't good enough. So yes, you can cash the cheque, and it's not in full and final settlement because there's no consideration. Now, if somebody says, look, I owe you £1,000 next month, but I'll pay you £600 now, will you take it? Yes, that would be a settlement because you're paying early. If you're changing the terms in some way, if somebody says, look, I owe you £1,000, but I'll give you $1,500, will you take that? Yes, that's good enough because it's different. But if it's just paying less, not good enough. What you'll typically get, though, is there's a compromise, there's an argument. I say you owe me £1,000, you don't think you do. So you send me a cheque and say, here's £600 in full and final settlement. And I cash the cheque. Have we done a deal? Well, it depends whether I intend to do a deal, because a settlement is a contract. And for there to be a contract, there has to be an offer and an acceptance. If I say to you, thank you very much for your cheque for £600, I don't accept that in full and final settlement, that's not good enough, but I cash it anyway, there isn't an agreement between us. There is not what the law calls an accord and satisfaction. An accord meaning an agreement. So if I cash the cheque and simultaneously write to you saying, thank you for your cheque for £600, not good enough, you owe me £1,000. I've cashed the cheque for £600, you still owe me £400, I'm fine. My advice generally is cash the cheque, write the letter, send it second class, make sure the cheque gets paid by the bank before they have a chance to cancel it. The question is there an offer to settle a dispute which is accepted? There was a case, for example, with the Inland Revenue. The Revenue was after a guy for tax, and he sent them a cheque and said, I don't think I owe you all that, here's my cheque for less in full and final settlement. And what happens when the Revenue gets a letter in, there's a cheque attached to it, in the post room, they tear the cheque off, send that to the bank, and the letter goes up to the officer who deals with it. And then a week, 2 weeks, several months later, they get to the letter in the pile, and she writes back to the business and says, no, that's not enough. And he says, but you cashed my cheque. You cashed my cheque, you didn't say anything at the time, we've settled. And the court said no. The Revenue hadn't addressed its mind to whether or not they were accepting that offer. They just cashed the cheque, because that's what they do with every cheque that comes in. Therefore, there wasn't an agreement, there was no accord, there was no deal, because the Revenue wrote back and said, no, we don't accept it. They were slightly lucky given the time to get away with it. But the answer generally is, yes, you can cash that cheque, say you don't accept it, and that'll be good enough. A problem you sometimes get, of course, is the other person thinks they've settled, and you may then get into a dispute. But typically a bird in the hand is going to be worth two in the bush. Often my advice to clients is, look, they've offered you a fair wad of money, take that, get that safe, but tell them you're still after the rest. I'm going to move on now because we've got a lot to cover in a short length of time. Mistakes. A settlement, as I said, is a contract. What happens if there's a mistake? If the parties don't agree on something? Well, as always with a contract, if one person makes a mistake, they've got something wrong, they misunderstood it, tough. The contract's clear, if you misunderstood it, tough. If both parties have been mistaken about the same thing, one person thinks it's black, one person thinks it's white, the court will do its best to work out what the deal is. And if the parties have actually made what's called a common mistake, then the contract is only void if it's fundamental. Basically, courts try to keep contracts alive. Why am I going through this? The answer is, again, the same point I've made before. Write down what you mean. If you're doing any deal, a settlement or any other contract, always make clear. Sometimes somebody says to me, look, I think the other guy's misunderstood this. I'm saying this, but he's got that bit wrong, and actually I'm going to hit him for more afterwards. My experience generally is that's the way of storing up trouble for yourselves. Usually all you're going to do is end up in another dispute further down the line with more time and trouble and expense you need. It's always best if you're doing a deal to be very, very clear about the deal that you're doing. And similarly, with misrepresentations in contracts. I'm sure you've all had the experience. Somebody tells you something in order to get you to enter into a contract, and it turns out to be wrong. Oh yeah, don't worry, you'll be able to do this. No, we won't enforce that. Yes, this widget will do whatever. A misrepresentation. Again, there's a lot of law involved in this. Misrepresentation can be innocent. The person genuinely made a mistake, they didn't know. It can be negligent, they should have known, but didn't. Or it can be fraudulent. They actually lied to you, or didn't take any care. And it's surprisingly easy to lie to somebody when they're trying to when you're trying to do a deal. If you don't pay me, I'm going to sue you. Now, that might be perfectly true, but it might just be one of those things we say. Technically, if you actually have no intention of suing them, if somebody says that to you, if you don't pay me, I'm going to sue you, and they have no intention of suing you anyway, that's a fraudulent misrepresentation. And if it turns out, and you can prove it, that it was untrue, then basically you can get out of the contract. It happened in a big case involving shares. Scrivener Vickers and old share brokers phoned up and said, look, I've got this great deal. If you don't buy these shares now, somebody else wants them. So you take them now, or I've got another buyer for them. Oh, great. They said, we'll take them. Unfortunately, the shares were in a company called Ferranti, which one or two older people here might remember, which very swiftly afterwards crashed. And the buyer was a little miffed about this, and they investigated, and it turned out there wasn't another buyer at all. It was just one of those things that salesmen say. Well, unfortunately for the salesman, the court wasn't impressed, and they had to pay the buyer back the entire amount. Be careful what you say, because a false representation of a material fact made prior to the compromise, which induces it, may, if the party misled wants to, get them out of the agreement. And that includes asserting a claim that you know to be baseless. If somebody tells you, I'm entitled to this from you, makes a claim, and they know it's false, that's a misrepresentation. A representation which was true at the time, but which was false before you actually do the deal, is a misrepresentation. Somebody says it gets you to do a deal on the basis of something, and that becomes untrue, and they know it, that's a misrepresentation. A statement of future conduct, I intend to do something, is not a misrepresentation if your intention changes, so long as you actually intended it at the time. But telling somebody you intend to do something when you don't is a misrepresentation. And again, any of these can, in suitable cases, get you out of a contract, or can mean that the contract you entered into is not going to be binding. So my advice always is, be clear, make sure you understand the deal, and if you're entering into a contract on the basis of what somebody's told you, write that down. I'm doing this deal because you have told me X. And that's the only reason I'm doing it. If that's important. I'll take some questions at the end if you don't mind, because our time's quite limited, but there will be some time for questions at the end, or I'll be happy to speak after. Enforcement. Okay. You've done a deal, or you're planning to do a deal. How are you actually going to enforce it? And this is, again, a question to ask with any contract. I'm a litigator. I'm a dispute resolutions lawyer. I'm a professional pessimist. The contracts come to me when they've all gone wrong. And I know that 99 times out of 100, people do deals, everything's fine, everybody's happy, nobody ever asks about all that boilerplate at the back. How are you going to enforce it? When they come to me, they've gone wrong. You can have two different types of settlement, basically. You can be settling court proceedings. Somebody has actually sued you, or you have sued somebody. And increasingly nowadays, with the costs and so on, you may well be doing that yourselves. Or nobody's got to court yet. It's just a deal. If you're in court, if somebody's sued you or you've sued somebody, then you can have what's called a consent order, which is an order made with the agreement of both parties. The court can only do that if it's entitled to do it. There are ways of doing a deal in court that are wiser than just money or whatever, called a Tomlin order. I'm not going to try to explain that. Very happy to answer questions if that's a topic somebody wants to know about. And if there's an order of the court, that can be enforced. So if somebody sues you for £1,000 and you say, look, I'll owe you 600, and they say, right, let's get a court order, consent order, and the court orders, yes, pay £600, that can be enforced just like any other court order, sending the bailiffs round or grabbing the bank account or whatever. Doesn't matter that it's by consent. Just because it's been agreed, it's still a perfectly valid court order. So you've got ordinary execution of a judgment. What you're much more likely to have, however, is there aren't court proceedings. You're just doing a deal. A settlement is a contract. It can be oral or written. My advice is generally write it down. That way you're going to be much clearer as to what it is. And it's a settlement. It's a defence to the original claim. If you've got a claim and you do a deal, your original claim disappears. And this is an important point to note. You owe me £1,000. You say, will you take 600? And there's consideration, there's a dispute, it's disputed. Take 600, I say, yes. You don't pay me. And I come to you and say, right, you owe me £1,000. You say, no, actually, we did a deal, I now owe you 600. And I say, yeah, but you haven't paid me. That's not what you said. We said we'd do a deal for 600. And that's now the deal. So if you're going to accept less money, for example, what is very important you say is, I'll accept £1,000, I'll accept 600 instead of 1,000, provided that you pay that amount by the 31st of October, and if you don't, you still owe me the full 1,000. That's critical, because otherwise, and this happened to me some years ago in practice, it was a big shipping case, millions of pounds involved. And our client said to the other side, look, we'll pay you a couple of million. They said yes. And my clients didn't pay because they have a shipping line and that's what they do. And the other side said, right, we're going to carry on with the court case now. We're going to see you for the whole lot. Sorry, we said you can't. You've just settled that claim. You have to start another claim with a new claim and sue us. And they were furious, but that's what they had to do. So a settlement, unless you agree otherwise, is a defence to the original claim. If you pay me the £600 by the date you agree, then we have settled. But if not, I'm going to carry on the original claim. Critical to say that and write it down. Contracts can be oral. There are very few types of contracts that must be in writing. A contract for the sale of land, for example, must be in writing or evidence in writing. Almost every contract you do in business is perfectly valid, whether it's handwritten and signed, whether it's by email, or whether it's just oral. An oral contract is perfectly binding. The problem with an oral contract, of course, is proving it. Sam Goldwyn, the Hollywood film producer, said an oral contract isn't worth the paper it's written on. If you've done an oral contract with somebody, sometimes you will do a deal orally, and you've just discussed it. If you've done that, write to them immediately afterwards. Email them, just confirming we have agreed A, B, C, and D. And if they don't write straight back to you and say, actually, no, we didn't agree that, when you end up in court several months later, and they're going to say, well, no, that was not what we agreed at all, the judge is going to say, well, why? When you got this email the next day saying that's what we agreed, didn't you say no? It's going to be good evidence of the oral contract. A settlement is a contract. I'll answer questions at the end, because time is pressing on. All the usual rules apply. Think about all the boilerplate. All that boring stuff at the back of those long contracts you see is usually there for a reason to do with if we have to sue each other. Think about enforcement as well. How's that going to happen if it needs to happen? That is a very quick canter through some things to think about when you are settling disputes for yourselves. It's not designed to turn you into a lawyer, because that's not what you want. It's designed to help you do that and avoid problems, and also to know when maybe there are issues when you need to see a lawyer. I hope that's been useful and interesting. Maybe not today, but I hope the time will come perhaps when you think, oh, hang on a minute, I knew something about that. If you'd like the slides for this talk, please email me. The address is up there. I'll be very happy to answer some questions now in a few minutes we've got left, or I'll be available afterwards, or I'm on stand 322 just over there. Very happy to speak to anybody. So, yes, you had a question. The question was asking whether doing a deal by email, which is because printing it out and sending it back by mail is a bit of a hassle. The answer is yes, basically, because, as I said, you can do a deal orally or by email. The question is being able to prove it. If somebody sends you here's my 20-page contract in a PDF, do you agree it? A one-word email back saying yes would suffice. That will be fine. Now, in practice, somebody might print it out, scan a signature. You'll often do that. But the question is, if I'm in front of a judge, am I going to be able to prove that that was agreed? And if you've got an email, then now emails are not 100%. In particular, they're actually fairly easy to forge. I've got a case at the moment where somebody's made a £20,000 claim against my client, and they said, well, hang on a minute, we didn't agree that. And the other side said, well, here's the emails. We sent an email to you saying, so you'll give us £20,000, and here's the email where you said yes. And my client said, we've never seen these emails. And I said, oh, well, actually, I can tell you how I know they're forged, they said. How's that, they said? Well, the date, it says if you look at the date, it says Thursday, November the 10th, 2011. But November the 10th, 2011 was a Wednesday. What the guy had done was he'd copied and pasted the header from further down, changed the date, but hadn't changed the day. Rather stupid, but people sometimes are. So that was the end of that, because we could very easily prove it was forged. So yes, emails are perfectly valid, but even with paper writing, forgeries are possible. Well, thanks very much, ladies and gentlemen. I hope that's been and will be of some interest to you. As I said, I'll be here for a few minutes after, and then on stand 322. If you want to. Thank you.